matter, the bench stating here is State through CBI versus Amarmani Tripathi and others, 2005. I am Singh as a judge for this Moot Court Presentation. Learned Counsel for the Appellant side, please introduce yourself.
Good morning, sir. This is Ritu, the Counsel appearing on behalf of the State through CBI.
Learned Counsel for the Respondent, please introduce yourself.
Good afternoon. I Shivsangi appear on behalf of the Respondent, Amarmani Tripathi and others.
Very well, Learned Counsel, you can proceed.
The Counsel seeks permission to approach the dice.
Permission granted.
May it please your Lordship, I appear on behalf of the Appellant, the State of Uttar Pradesh, to the CBI in criminal appeal number 1248 of 2005, arising out of special leave petition number 3503 of 2004, along with connected criminal appeal number 1249 of 2005. If your Lordship may permit, I shall now proceed to place the procedural history of the matter. Much obliged. Your Lordship, with your leave, I shall briefly trace the procedural history of the matter. On 19th May 2003, the deceased, Madhumita Shukla, was shot dead at her residence in Pepperville Colony, Lucknow. A report was lodged the same day and the investigation was thereafter transferred to the Crime Branch CID on 17th May. On the State's own request, Your Lordship, the investigation was handed over to the CBI on 17th June 2003. The respondent, Amarmani Tripathi, was arrested on 23rd September 2003 and a charge sheet was filed on 19th December 2003 against 6 accused, including respondent Amarmani Tripathi and his wife Madhumani Tripathi. Initially, Your Lordship, Sessions Court has refused the bail application of the accused, but subsequently it was allowed by the High Court on 8th July 2004. Aggrieved by this order, Your Lordship, the State through the CBI approached this Honourable Court by way of special leave petition. If Your Lordship permits, I shall now address the jurisdiction of the Honourable Court in the present matter. Much obliged. Your Lordship, the appellant has approached this Honourable Court under Article 136 of the Constitution of India, invoking its discretionary appellate jurisdiction against the said orders of the High Court, granting bail to the respondents under Section 439 of CRPC. Leave having been granted, the special leave petition now stands before this Honourable Court at the present criminal appeal. With Your Lordship's leave, I shall now turn to the facts giving rise to the present appeal. Much obliged, Your Lordship. Turning now to the facts, Your Lordship, briefly stated, the case concerns the murder of Madhumita Shukla, a young poetess who was shot dead at her own residence while approximately 6 months pregnant. The post-mortem revealed the pregnancy and a DNA test established the respondent Amarmani Tripathi, then a sitting minister in the government of UP, as the father of the fetus. The prosecution's case, Your Lordship, is that the respondent's wife, Madhumani Tripathi, aggrieved by her husband's illegitimate relationship with the deceased, engaged persons to eliminate her, and that the respondent, upon being informed of the plan, considered to it on the condition that his own name must be kept out of the matter. The murder was carried out by 2 hired men, namely Santosh Rai and Prakash, on 19th May 2003. Your Lordship, apart from the confessional statement of co-accused Rohit, the prosecution also relies upon independent material, including statements recorded under Section 161 of the CRPC, indicating that the respondent interfered with the investigation, procured the transfer of officers who didn't cooperate with the fabricated narrative, and warned witnesses against implicating him as well. That, Your Lordship, in brief, is the factual matrix. If Your Lordship has no further questions on the facts, I shall now proceed to the issues framed in the present appeal.
So, Counsel, you are just suggesting that the offence is very grave and serious. So, on this matter only, there should not be granted
Certainly, Your Lordship, that I am going to discuss in issue number 1, if you allow. the offence. Now coming on to issue number 1. The question before this honorable court is whether the respondents were rightly granted bail despite the gravity and circumstances of alleged offence. Your Lordship, the first and foremost consideration in this regard is the gravity of the offence. The allegation is not an ordinary criminal offence. The case concerns the premeditated killing of a woman who was approximately 6 months pregnant at the time of her murder. And that too, the deceased was murdered within the privacy of her own residence. Here I would like to highlight a few cases, Your Lordship. In Banaras Hindu versus NCT Delhi 2001 and Kalyan Chandra Sarkar versus Rajesh Ranjan 2004, this honorable court has recognized that in cases involving offences punishable with life imprisonment and death, the court must carefully examine whether there exists reasonable grounds to believe that the accused is in guilt. The appellant therefore respectfully submits that the gravity of the offence cannot be treated as mere background circumstances. It must be considered together with the prima facie material and the surrounding conduct of the accused. Your Lordship, this is all from my side regarding issue number 1, subject to a brief rebuttal if necessary.
Counsel seeks permission for court-style. With the kind permission of this honorable court, I seek to proceed with my submission. Much obliged. I shall be addressing this honorable court on the issue number 1. I will now address the issue of gravity of the offence and its relevance to grant of bail. Your Lordship, it is respectfully submitted that while the gravity of the offence is an important factor, it cannot be by itself be a sufficient ground for denying or cancelling bail. If gravity alone was sufficient to deny bail, then an accused facing a murder charge could never be granted bail during the pendency of the trial. For this, I would like to highlight the case which is honorable court in the case State of Rajasthan versus Balchan in 1977 and Kutti Kanti Narsin Guru versus Public Prosecutor in 1978. Court itself recognized that even in the serious offence, the court must consider other relevant factors, particularly the likelihood of the accused absconding and the possibility of accused interfering with the fair conduct of the trial. Coming to the facts of the present case, Your Lordship, the respondent do not dispute the seriousness of the murder. However, the crucial question before this honorable court is whether respondent were in fact involved in the commission of the offence. It is respectfully submitted that the prosecution case regarding respondent's involvement is doubtful as it rests substantially upon the retracted confession.
I object, Your Lordship.
I agree with the accused.
As my learned friend just stated, that the accusation is substantially relying upon retracted confession. I would like to remind to my learned friend that the confession by Rohit, the approver, is being retracted only because of the fact, accusation, coercion and inducement of the accused Amarmani itself.
So, Counsel, you have been a very nice question. You are the minister. Okay, you are the part of the system. You are controlling the system. Then there can be some consideration from your side to the officials who are investigating the case. So, by granting bail, there can be further made to the accused part who can just reveal the evidence or not.
Lordship, with due respect to the contention raised by my learned friend, it is not supported by any prima facie evidence on record. There is no evidence before this honorable court to establish that the approver Rohit Chaturvedi was subjected to any threat, coercion or any abuse. If your Lordship is satisfied with my answer, I may respectfully proceed with my submission. Much obliged, Your Lordship. The Honorable High Court rightly kept the undisputed gravity of the murder separate from the contested question of the respondent's role in it. As far as her husband, and the purchase allegedly handed to the assailants remain unverified as being in her handwriting. The gravity of crime cannot substitute for the absence of evidence tying a specific accused to it. Your Lordship, this is my submission regarding the issue number 1.
Your Lordship, my learned friend has correctly stated that general proposition, the bail is the truth and jail the exception. But the proposition does not answer the facts before this court. The appellant is not relying upon gravity in isolation. We rely upon gravity coupled with the prima facie material, the alleged role of respondents, and most importantly, the subsequent conduct indicating interference with investigation and witness tampering as well. This therefore is not a case where gravity alone is being used to deny the bail. Accordingly, Your Lordship, that is from my side regarding issue number 1. If Your Lordship do not have any further questions regarding issue number 1, I shall now proceed to issue number 2. So issue number 2 in this matter is whether there was sufficient prima facie material establishing criminal conspiracy against the respondents. Coming on to issue number 2, it is respectfully submitted that sufficient prima facie material existed to connect the respondents with the alleged criminal conspiracy. At the outset, Your Lordship, I respectfully submit that the appellant is not required to establish conspiracy beyond reasonable doubt at this stage. Conspiracy by its very nature is secretive, so direct evidence of an agreement is therefore rarely available, and this honorable court may draw a prima facie inference from the surrounding circumstances and the conduct of the party. In the present matter, Your Lordship, the circumstances are not isolated, rather, they form a sequence which I shall place before this court point by point. Now count them on your fingers. Firstly, Your Lordship, there was a clear motive. The prosecution relies upon the response. Pardon, Your Lordship. Firstly, there was a clear motive. The record establishes through DNA evidence that the respondent Amarmani was the father of the fetus carried out by the deceased, and that this followed 2 earlier pregnancies which had been terminated in his instance only. Secondly, Your Lordship, the prosecution relies upon the response attributed to the respondent Amarmani. When informed of the plan against the deceased that the act may be done, provided his name must be kept out of the matter. An assurance coupled with the position as a sitting minister to shield those involved. Equally, the conduct of Amarmani Tripathi in pressing for urgent execution of the plan forms part of the same transaction as well. Thirdly, and most importantly, Your Lordship, the prosecution relies upon the subsequent conduct of the respondent, including the alleged attempts to prevent preservation of the fetus, the fabricated marriage narrative, and the alleged transfers of the investigating officer. Your Lordship, each of these circumstances may perhaps be viewed separated by the respondents. However, criminal conspiracy is to be assessed from circumstances collectively and not in isolated fragments.
So, Counsel, there are 2 competing conspiracy. So, the court should begin on each procedure only.
Certainly, Your Lordship, the existence of different possibilities by which the prosecution seeks to establish the conspiracy does not automatically deny the prima facie case itself. This honorable court at this stage is not required to finally determine the internal mechanics of conspiracy. The question is appropriately tested in trial on the basis of evidence itself. Therefore, Your Lordship, the appellant respectfully submits the material on record when viewed cumulatively was sufficient to raise prima facie case of conspiracy against the respondent. Lordship is satisfied with the answer. This is all from my side regarding issue number 2.
Your Lordship, with the kind permission of this honorable court, I now proceed with the issue number 2. Much obliged, Your Lordship. Your Lordship, prima facie material must be material, not moral suspicion dressed up as an inference. If Your Lordship keep aside the retracted confession of Rohit Chaturvedi, as I assert, Your Lordship, retracted confession, which the Honorable High Court itself treated with caution. What remains against the respondent is in essence an illicit relationship, a DNA report establishing paternity, alleged pressure to terminate the pregnancy, and the undated letter expressing grievance. Your Lordship, even if all these circumstances are accepted at face value, they may at best show that respondent number 1, Amarmani Tripathi, had a relationship with the deceased, that he was the father of her unborn child, and that there was an attempt to conceal that relationship. This does not mean by itself prove that he conspired to murder her. Motive may create suspicion, but it cannot be by itself establish conspiracy. The case against the respondent number 2, Mrs. Madhumani Tripathi, is even weaker. The prosecution relies mainly on mobile phone records that were even not registered in her name, an unverified handwritten note, and the same retracted confession of the Rohit Chaturvedi. Your Lordship, anger, jealousy, marital conflict may explain a person's emotions, but emotion cannot be transformed into evidence of murder. To establish conspiracy, there must be credible material showing a clear connection between the accused and the alleged criminal plan.
Counsel just tell me, is the absence of direct evidence ground for denying custodiality to them?
Yes, Your Lordship, excluding the retracted confession of co-accused.
So in this case, which is just like a heinous crime, apart from murdering a mother with its fetus, two more suicide was done. His abortion was done from him. So, if your client had nothing to hide, so at some instances, he tried to just clear the evidence.
Your Lordship, my client conduct must be viewed in the light of his position as a sitting minister, facing the exposure of extramarital affair. An act of concealing personal scandal is not by itself evidence of concealing a murder. The prosecution cannot equate an attempt to protect one's political reputation with a conspiracy to commit the homicide. As Your Lordship, if Your Lordship satisfied with my answer, I would like to end my summation here.
With the Lordship's kind permission, I shall now proceed to the final issue, that is issue number 3. Issue number 3 in this matter is whether the allegation of interference with investigation and witness tampering was sufficient to justify cancellation of bail. The appellant respectfully submits that this issue constitutes the strongest ground for interference with the impugned order. The issue, my lord, is not merely about what the respondents allegedly did before the offence. It concerns what they allegedly did in relation to the investigation itself. If your lordship permit me, I would like to place the sequence of events before this court. Firstly, your lordship, on the night of the murder, the respondent Amarmani allegedly contacted SSP Agarwal and asserted that his wife Madhumani had nothing to do with the offence, even before any such involvement of his wife has been raised. Secondly, your lordship, when the SSP learned of the pregnancy and directed that the fetus must be preserved for DNA examination, the respondent allegedly made further efforts to have the body released without any such sort of preservation. Thirdly, your lordship, the prosecution alleges that a false narrative concerning a marriage between the deceased and some Anuj Mishra was introduced, which is completely a fabricated and fake story. Fourthly, Sub-Inspector Narayan Dixit was allegedly being deployed to obtain support for the false narrative. And finally, your lordship, officers who did cooperate with the proposed narrative were allegedly being transferred. Your lordship, viewed individually, the respondents may seek to explain away each of these circumstances, but viewed sequentially, the appellant submits that they demonstrate a disturbing pattern of interference with the investigation itself.
So, counsel, there is a direct evidence that Amarmani is involved in the transfer of bad offices. Is there any detailed this is
appellant acknowledges that there may not be a direct written instructions bearing the respondent's signature. However, the prosecution relies upon the timing, the sequence, and surrounding circumstances, which taken together paint a very clear and telling picture. The relevant question at this stage is whether those circumstances create a reasonable apprehension that the respondent possessed both the ability and the inclination to interfere with the investigation. And Your Lordship, it certainly does. Now moving to witness tampering, Your Lordship, the prosecution further alleges that the respondent confronted the sister and the mother of deceased near the mortuary and warned them against implicating him. The appellant submits that such conduct is directly relevant to the question of whether the respondent, permitted to remain at liberty, could have easily influenced witnesses similarly in future as well. Therefore, Your Lordship, the appellant respectfully submits that the material before the High Court disclosed not merely the theoretical possibility of interference, but circumstances demonstrating an actual and continuing capacity to influence the course of investigation. The possibility of witness intimidation, manipulation of evidence, and interference with investigating officers is particularly serious in such nature of crime. Accordingly, issue number 3 ought to be answered in favor of the appellant. If Your Lordship has no further questions, that's all from my side regarding issue.
Your Lordship, with the kind permission of this honorable court, I now proceed with the issue number 3, which is last. Much obliged. Your Lordship, it is respectfully submitted that the allegations against the respondent are not supported by tested and reliable evidence. Firstly, on the transfer of police officers, the prosecution relies on the fact that certain police officers were transferred during the investigation. However, in the Uttar Pradesh, police transfer are a normal administrative practice. I assert, Your Lordship, normal is administrative practice. There is no signature of respondent number 1, Amarmani Tripathi, nor any written instruction connecting him to these transfers. Merely because an officer were transferred, it cannot be presumed that the transfer was engineered by the respondent by way of retaliation. Secondly, on the statement of the officers and the SSP's account of phone calls, there are at present only statement recorded under section 161 of CRPC. They have never been tested through cross-examination and have also not disputed by the respondent. As this honorable court itself in Daulat Ram versus State of Haryana has held that allegations which are tested through, pardon Your Lordship, which are untested through cross-examination cannot by themselves be treated as sufficient grounds for cancellation of bail. Such matter ought properly to be examined during the trial where witness can be examined or cross-examined. Most importantly, these allegations remain unverified and hence unreliable. Thirdly, Your Lordship, it is respectfully submitted that the complaints in question were received by the CBI itself, the very agency of the prosecuting this case, and are not supported by any independent, tested or reliable evidence. A person cannot be denied bail merely on the basis of a possibility or assumption about what he might do. Therefore, in the absence of strong, cognate and reliable material showing misuse of liberty or interference with the administration of the justice, the respondent respectfully submit that there is no sufficient ground for cancellation of bail. If Your Lordship have any question regarding the issue.
So, you should just tell me who you are asking to give greater weight to the neighborhood of the athlete. So, just tell me, protection of witness is a serious order case. You are the minister. So, there are chances that evidences can be erased and further the investigation can be objective. There can be some disturbances in the investigation. So why the court should give more weight to the liberty of the athlete in spite of having such heinous and serious crime?
Because, Your Lordship, these were only allegations. There was no verification or independent material to establish that the respondent has actually threatened or influenced anyone.
So why you attempted to just deny the DNA testing of fetus? It was good preserved.
Because, Your Lordship, my client is a sitting minister facing the exposure of an extramarital affair. That's why he's concealing the fact about the pregnancy.
So being the minister in your state, it is your responsibility to be an ideal or the citizen of this state. And just for an allegation, such a serious crime has been committed. So you should look at that. You can proceed.
The prosecution cannot equate an attempt to protect one's political reputation with a conspiracy to commit homicide. This is my submission regarding the external.
If the Lordship has no further questions regarding the submissions I made earlier, the Counsel seeks permission to proceed with prayer. Much obliged, Your Lordship. Therefore, in light of the facts, circumstances and submissions made herein, it is most respectfully prayed that this honorable court may be pleased to, firstly, allow the present appeals filed by the state of Uttar Pradesh to CBI, secondly, set aside the orders of Allahabad High Court granting bail to the respondent, thirdly, cancel the bail bonds executed by the respondents and direct the respondents to surrender forthwith and in default, direct the state to take appropriate steps for securing their custody, and finally, pass any other order that this honorable court may deem fit and proper in the interest of justice, fairness, and proper administration of criminal law. And for this act of kindness, the appellant, as in duty bound, shall ever obey. Thank you.
If the Lordship does not have any question regarding the submission I have made, the Counsel seeks permission to proceed with the prayer. Wherefore, in the light of the facts, circumstances, and submission made herein, it is most respectfully prayed that this honorable court may be pleased to firstly dismiss the appeal filed by the state of Uttar Pradesh to CBI. Secondly, uphold the orders of the Allahabad High Court granting bail to the respondent. Thirdly, hold that the High Court correctly exercised judicial discretion under Section 439 CRPC. Fourthly, hold that the prosecution material, particularly the retracted confession of co-accused, did not justify interference with the respondent liberty at the stage of bail. And lastly, pass any order that this honorable court may be fit and proper in the interest of justice and equity. And for this act of kindness, the respondent, as in duty bound, shall never obey. Thank you.
Having heard appellant side as well as respondent side, and upon consideration of material placed before us, we proceed further to give the judgment, and further detailed judgment will be uploaded on the site of the Supreme Court. As of now, accordingly, the appeals filed by the CBI are allowed. The order of the Allahabad High Court in granting bail to the accused is dismissed. Their bail bonds are cancelled and they are directed to surrender forthwith. In default, the state shall take appropriate steps to take them in custody. The appeals are accordingly allowed and disposed of.